All right. Well, good morning, everyone. Welcome back. Welcome to day 3, Enforcement Day, best day. Um, look, without further ado, let me introduce Sanjay Wadhwa. Sanjay, thank you for joining us. I'll introduce him briefly, even though he really needs no introduction. Sanjay is the acting director of the SEC's Division of Enforcement. He became the deputy director of the division in August 2021 after serving as the senior associate director for enforcement in the New York regional office of the SEC. Sanjay joined the SEC in 2003 as a staff attorney and rose to become the co-head of enforcement in the New York office, overseeing the day-to-day functions of its enforcement program, and previously served in other roles at the agency, including deputy chief of the market abuse unit and assistant director of the New York office. And so we're very lucky to have you here today. Thank you. Oh, we can't hear you. Oh.
Now we got you.
Oh, yes, there we go. That's excellent. Thanks, Sanjay. So I know you have some prepared remarks, and then we'll do some Q&A.
All right, thank you. Thank you for that introduction, and good morning, everyone. Thank you to PLI for organizing this event and for the opportunity to address this audience. I imagine a packed room right now. I can't really see it, but I hope everybody's seated and on the edge of their seats. My apologies for not being able to be there in person. As is customary, my remarks today are in my official capacity as acting director of the SEC's Division of Enforcement and do not necessarily reflect the views of the Commission, the individual commissioners, or other members of the staff. I'd like to take the opportunity today to reflect on some of the goals and intentions that then Director Gurbir Grewal and I, as his deputy, discussed when we assumed leadership of this remarkable division 3+ years ago, and what I hope to see for the division and its dedicated personnel going forward. Since 2021, Gurbir and I frequently discussed, including at conferences like this one, that we would prioritize restoring investor trust and confidence in the financial markets by emphasizing robust enforcement that works to promote a culture of compliance among market participants. We explained that this included empowering frontline enforcement staff by largely deferring to their judgment on various issues in our investigations and in our recommendations to the Commission. We explained that we would do this because enforcement staff are immensely talented and possess great experience and judgment, and 2, they are in the best position to know the ins and outs of their investigations, the quality of their evidence, and the tenor and substance of interactions with defense counsel. We have done that, and I think the work of the division over the past 3+ years has shown that our confidence in our enforcement colleagues was well placed. Enforcement staff have used their judgment wisely and appropriately, conducting investigations diligently but with urgency and without fear or favor, following the facts where they may lead to protect investors across the industry. That is, after all, our mission, and this Commission and its enforcement staff have endeavored to fulfill it on a daily basis. This has resulted in consequential enforcement actions, addressing material misstatements by public companies, wholesale failures by gatekeepers to comply with their professional obligations, and failures by advisory firms to disclose and guard against conflicts of interest. It has resulted in actions alleging that insiders abuse their position for personal gain. And of course, it has resulted in actions alleging massive frauds by various types of market participants. Those enforcement actions have protected innumerable investors, both by putting an end to the specific conduct at issue, but also by deterring other market participants who saw the Commission act forcefully and in response remediated their own violations or redoubled their efforts at compliance. Now, when Gurbir and I discussed our efforts to empower frontline enforcement staff, there were some concerns in the defense bar that this would result in staff adopting unreasonable stances or that good faith efforts by market participants to comply would be disregarded. From my perspective, those concerns were misplaced. For one, enforcement attorneys understand and appreciate the tremendous impact that an SEC investigation can have on parties that may find themselves in our crosshairs. Accordingly, giving process is part of the DNA of this division. For example, the Wells process remains a meaningful one for parties to make their arguments to the enforcement division, even without the front office participating in every meeting. And as defense counsel, many of whom are likely in that room right now, as defense counsel that work with us regularly can attest, these meetings at times result in staff recommending reduced charges or even declining to recommend charges at all. The empowerment of enforcement staff involved both carrots and sticks. Not only did we say we would largely defer to their judgment on charges, but more importantly, we told them to use their judgment in recommending that the commission reward parties that self-policed, self-reported, remediated, or otherwise meaningfully cooperated with our investigations. Time and again, staff embraced our call on this point and asked Gurbir and me to consider those efforts by prospective defendants and respondents, and we in turn agreed to recommend resolutions to the commission that imposed reduced penalties or even zero penalties. Or where parties have remediated those violations, we have taken that into account in determining what, if any, undertakings or other remedies to recommend. This has even included actions involving recidivists and major firms, and it illustrates exactly what we mean by emphasizing robust enforcement while working to create or promote a culture of compliance among market participants. Because only by working together can we, that is the regulator and the regulated, maintain investors' trust in the markets. Now, you may ask yourself, given the proactive remediation I just mentioned, why then do we need an enforcement division? Let me be clear. In my view, this is, indeed it has to be, a joint undertaking where internal or in-house compliance complements the Commission's enforcement efforts. This is because self-regulation is not a substitute for regulatory enforcement. No matter how much we promote a culture of compliance or message the benefits of self-policing and self-reporting and proactive remediation, or even appeal to market participants' better nature, there will always be those who cut corners, those who choose non-compliance, either deliberately or by underinvesting in their compliance functions. The incentives are simply too great without a strong enforcement division holding such parties in check. After all, compliance has costs. There are the actual resources needed to implement effective compliance functions, and there are also the opportunity costs that may come from accurate disclosures. For example, when disappointing financial figures drive investors elsewhere. But one need only look at the state of the securities markets before the enactment of the Securities Act of 1933 and the Securities Exchange Act of 1934 for a sense of what happens when market participants are restrained only by their own judgment. The marketplace therefore needs an enforcement division that is strong and that brings meaningful enforcement actions. Actions that correct misbehavior before it spirals out of control and destroys investor wealth and investor confidence in the markets. In fact, we have telegraphed in clear terms that one of the ways we achieve compliance is by reversing the incentives, by imposing penalties and other remedies that make it clear to market participants that complying with the securities laws is cheaper than violating those laws. Certainly, I am sure that it is not lost on anyone that the increased self-reporting and other cooperation that we have been highlighting has come during a time of record civil penalties. Those record penalties help incentivize companies to adequately invest in their compliance departments and empower their compliance personnel, which in turn protects investors and the markets. Ultimately, of course, protecting investors and promoting the integrity of the markets is what drives us all in the Division of Enforcement. And that should be a shared goal among all of us here. Securities law violations, whether they involve negligence, so-called technical violations, or deliberate intent to defraud, erode the integrity of the markets and undermine investor trust in our capital markets. It is therefore crucial that the Division of Enforcement have the ability to enforce compliance across the industry, addressing investor risk wherever and in whatever context it arises, and whether it involves major global companies, small firms, or executives or senior officers. It is my hope that going forward, we will continue to see respect for the investigative process and for the judgment of the professionals in the Division of Enforcement, that the division will continue to operate as an effective watchman, ensuring that all market participants across the industry comply with their legal and regulatory obligations. The stakes are just too high for it to be otherwise. The continued success of our capital markets, which are the envy of the world and the engine of economic activity, depends on it, and the trust of the average investor turns on it. Over the last 3+ years, the work of the division, its dedicated staff, and the many market participants that have heeded our call to embrace our shared mission of protecting investors has been a great source of pride for me, and I hope we can continue to build on that effort going forward. Thank you.
Thanks, Sanjay. Thanks for the remarks, and very thoughtful. You know, you and I spoke last week on this issue of cooperation, and it's helpful, I think, for this crowd to hear you flesh that out a bit. So thank you. And also to give a sense of, you know, a good sense to folks that there are circumstances where cooperation does result in walking away or reduced charges, which I think, as you and I discussed in other conferences, this is kind of the holy grail for a lot of companies in thinking about, you know, should we self-report? What do we get for it? Is there an opportunity for there not to be a case? So helpful to hear you flesh that out a bit. You know, I'll sort of jump in and appreciate your time in you know, answering a few questions for us. It's an interesting time to be acting director. I know what it feels like. I've done it too during a transition, and it's an interesting time. You knew you were going to have to lead through a transition when you took the job. And it obviously is more complicated when there's a change in political party. How do you think about, you know, how are you leading the staff through this, the enforcement staff through this? What guidance are you giving them? Anything in particular, you know, folks are trying to get done in this window? It's often a time for a flurry of activity. What can you share with us about how you're leading now?
That's a good question, certainly a timely one, Steph. Look, our mission remains the same. Our focus on our mission should, and I think is the same as it was prior to last Tuesday. The vast majority of our staff is comprised of long-tenured employees who are consummate professionals. They've been through changes in administrations and changes in political party as well. They know what to do. That said, we do have a large number of newly hired staffers for whom this is a first. And the advice that we've given through the SOs, or that I have given to folks who've dropped by my office, is that the work of the division it remains paramount. We keep our heads down and keep doing the good work that the American public has come to expect of us. No one has asked us to put our pencils down. No one has said, let's take a breather, a holiday until Inauguration Day. None of that has come in to the Division of Enforcement from anybody among the commissioners. Our mission is to protect investors. And we've always been, and you know this, we've always been a mission-driven division. Focusing on our work, that is within our control. As for forces outside our control, as I've said to innumerable people, we'll contend with them at an appropriate time. But for now, our work continues with the same degree of urgency as before. We went through an incredibly busy phase over the summer, as folks across the table from us know, and that pace of work did not slow down in October. In fact, October 2024 was the busiest first month of the fiscal year we've had in over 2 decades. So we are continuing to work with urgency because the mandate is an all-important one. We protect investors. We protect the integrity of the marketplace. What comes down the road, we'll deal with when it does.
Yep.
But for now, the focus is on the work.
That all makes sense, and you're exactly right. The staff is incredibly long tenured, and really doesn't, big picture, change much. Administration over administration. That's certainly been my experience as well. This is a Corp Fin crowd, Sanjay, and so, lots of folks
should get
here.
out of here.
I know. That's why I'm so excited for Enforcement Day. And there's been lots of talk about lots of disclosure issues. And folks here in this crowd look to enforcement actions, for guidance. On issues that they should be considering. There's been a lot of talk about what they can take away from different types of enforcement cases. I thought maybe I'd ask you about a few. One of the things we've seen, I shouldn't say a lot of, there haven't been many cases, are sort of standalone disclosure controls and procedures cases. That's a thing that gets talked about a lot in these circles. There haven't actually been a ton of cases that are really standalone. I mean, I think this administration brought the first American case fairly early on, and was that sort of case. But we've certainly seen that be a focus of a lot of investigations. That's been a lot of our experience. What can you share with us about how the commission's thinking, the staff really is thinking about these cases? And we First American is the one I point to as a cyber case. We can talk more about the cyber disclosure cases, but any guidance or anything you can give folks in this space?
That's a fair question, a good question. I think we've been sort of accused of overreaching when it comes to disclosures in the cyberspace. Or us finding that these disclosures are materially misleading or not adequate enough. Let's just talk about cyber intrusion and what happens, because while I can't talk about SolarWinds, I know it's on a lot of people's minds, because it's a live litigation, so yeah. I'm not going to go there. But we did charge 4 companies for misleading disclosures around the effect of the SolarWinds breach on those companies. And that was a case that we just filed some weeks ago, settled actions that we filed some weeks ago. And I think some of the feedback that I received was, are you now requiring companies to provide a roadmap?
Yes.
Of exactly what happened. How do you square these cases with the commission staff's 2018 guidance on cyber disclosure? Let me first start by assuring everybody that we're not asking for companies to provide a roadmap. But let me also back up for a minute. Market participants today, they possess an incredible amount of electronic data about entities and individuals, including PII, sensitive financial account information, and other information that is of incredible value to bad actors. And as we have seen time and again, unscrupulous actors will try to access that data without authorization. So our goal is not to bring about a charge, have like this gotcha moment, re-victimize companies that have been targeted. Our goal is to prevent the risk of further victimization of investors, of shareholders, by ensuring that companies do not provide misleading disclosures about their cybersecurity or about cybersecurity incidents that they may have encountered. The 2018 guidance does say, and I'm quoting from it at this point, it does say, we do not expect companies to publicly disclose specific technical information about their cybersecurity systems, their related networks and devices, or potential system vulnerabilities in such detail as would make such systems, networks, and devices more susceptible to a cybersecurity incident. And that is eminently reasonable and logical. But it goes on to say, nevertheless, we expect companies to disclose cybersecurity risks and incidents that are material to investors, including the concomitant financial, legal, or reputational consequences. So, of course, the court's decision this summer on SolarWinds' motion to dismiss got a lot of attention. And again, because it's ongoing litigation, I'm somewhat limited in what I can say about it, but people tend to focus on the claims that were dismissed. I think folks should also be aware that the court sustained our claims that the company had made false claims about its cybersecurity. In short, the court agreed that companies cannot claim to be doing things with respect to cybersecurity that they're not doing. So I would really encourage the audience to read the opinion so you're not just relying on headlines, which did not capture what the judge really decided. I mean, suffice it to say, cyber disclosures are a matter of high importance to us all, you and us. So we're going to continue to investigate those cases based on their individual facts and circumstances. And where it's appropriate, we will recommend enforcement actions. I mean, this includes where parties fail to design effective disclosure controls and procedures regarding their cybersecurity information. A few months ago, we brought a case against R.R. Donnelly. And again, to the extent members in your audience has not looked at that case or read that case, I would.
Oh, they have.
I would suggest they do.
Oh, they have.
So I think, I mean, disclosure controls, and procedures are important because they have an impact on investors. They have an impact on the securities markets.
Yep, appreciate the explanation and your thoughts on it. There has been a lot of conversation here around those cases, around SolarWinds, around the accounting controls issue you alluded to in R.R. Donnelly. So folks are most definitely reading these cases closely and trying to figure out, what is the message for what's expected. So that's helpful background. The other thing that's gotten a lot of play at this conference in the last 2 days, in fact, there were 2 panels on it, is ESG. And would be interested in what you can tell us about the Enforcement Division's current focus on ESG. I mean, early in this administration, the division created the ESG task force, which you led for some time. That at least seems to have been disbanded. What, if anything, can you tell us both about the task force, about the division's continued focus on ESG stuff?
So with respect to the task force, you're right, it was created early on in this administration, although I think it was prior to Chair Gensler taking the helm of the commission. The mission or the mandate of the task force was to help enforcement staff liaise with our rulemaking divisions, whether it was CorpFin or other policy divisions, to get a better understanding of ESG-related issues. What do I mean by that? What I mean is where disclosures pertaining to ESG, whether those disclosures were satisfactory or adequate. That process with the task, and there was this misapprehension in the marketplace that this task force was going to bring its own enforcement actions. In fact, that was not the case, and the press release announcing the formation and the launch of the task force made that very clear. The idea was for a think tank type approach here with staff attorneys from enforcement, staff attorneys and supervisors from enforcement, volunteering to be members of this task force. They still had their day jobs. And trying to get a sense for the disclosures that were out there in this space. And once they had a sense for sort of the four corners of what constituted adequate disclosure, or to flip that, what didn't, following heavy consultations with folks in other divisions, the idea was to disseminate this knowledge more widely within the enforcement division. That happened. And so it got to a point where it did make sense to disband, to sunset the task force so that people could, because by then the average staff attorney at the commission in the Division of Enforcement understood when they looked at disclosures, they understood whether those disclosures, whether there were issues with those disclosures. Look, I mean, as has always been the case, we treat disclosures the same, no matter in what space we're viewing them. So disclosures about ESG are treated the same as other disclosures. And from our perspective, firms should simply make sure that when they speak on ESG issues, or for that matter, any issue, the disclosures are not materially false or misleading. As I think you know all too well, we sort of apply long-standing principles of disclosure, and as it applies to public companies, and long-standing principles of fiduciary duty as it applies to investment advisors. So ESG continues to be important to investors, and we continue to see firms making materially misleading disclosures in this space, but the sort of original need for the task force had gone away, and that is why we took it down. With respect to ESG disclosure actions, again, I'm sure folks in the audience know this, but just last week, the Commission announced settled charges against registered investment advisor Invesco with making misleading statements about the percentage of its AUM that integrated ESG factors in investment decisions. Invesco represented that between 70 and 94% of its parent company's assets under management were ESG integrated. But our investigation showed that that simply wasn't the case. So there's an example of a firm, in my opinion, seeing commercial value in claiming that a high percentage of company-wide assets are ESG integrated, but not really ensuring that that was actually the case. We also, just last month, announced settled charges against WisdomTree, another registered investment advisor, for failing to adhere to its own stated investment criteria for ESG marketed funds. I mean, WisdomTree represented that 3 ESG marketed ETFs would not invest in companies involved in fossil fuels and tobacco, but the ETFs did. They invested in companies involved in those activities. So these cases reflect a pretty straightforward proposition that lies at the heart of the federal securities laws. Disclosures cannot be materially false or misleading.
It's funny what you said at the outset about the cases that you all brought, because I think it's the same reaction, certainly that I've had and that most people have had, which is they've all really relied upon traditional securities law, existing rules and regulations. They've all been what I'd call fairly regular way disclosure cases. In the end, right? You say you're doing a thing and you're not really doing the thing. So it's been interesting to see. Well, I think we're sort of out of time. Grace has given me the look, so which I've been getting a lot of. But thank you, Sanjay. Really do appreciate your remarks this morning. It was a great set of remarks and a great Q&A and an opportunity to get your views on things. So thanks again.
Thank you for having me, Steph, and apologies again for not being able to make it there in person.
No, we're glad you could join us. Thanks.
Thank you.